Attorney Mike Monteforte here, and today I'm answering the question, what is a durable power of attorney? So first of all, leaving the durable part aside for just a second, what is a power of attorney? Well, a power of attorney is a document that will allow you to designate someone. It can be an individual, individuals, or even a corporate entity that can act on your behalf in the circumstance where you can't act for yourself. So if you become incapacitated in some way, you get sick, you're in a coma, and you're unable to make financial decisions for yourself, the power of attorney document is used to appoint someone to make those decisions for you. Sometimes power of attorney documents are made just as a matter of convenience. If someone is not going to be around because they're going on vacation or not going to be local to wherever some sort of document signing is going to take place, they can appoint someone as their power of attorney to sign for them. That happens very, very often in real estate transactions where a seller of a property might appoint their lawyer or another person to act as power of attorney for them and sign for them at their transaction. And that's got nothing to do with anyone's illness or incapacity, it's just a matter of convenience. When we talk about signing for someone because they have become ill or become incapacitated or lost their mental capacity, that's where the durable term comes into play. A power of attorney document is called durable if it survives your subsequent incapacity or loss of your mental faculties. Most of the time for estate planning, the power of attorney document that we utilize is a durable power of attorney because we want that authority to survive your subsequent incapacity. If you became incapacitated, sick, ill, or lose your mental competency for any reason, we want your power of attorney to then be able to act on your behalf. And a power of attorney that allows for that is called a durable power of attorney. Now, one other aspect that we utilize very often in our power of attorney documents is what's called a springing power. Now, some power of attorney documents create authority in your designated person immediately. As soon as you sign that document, you've empowered your designated individual, and we use that very often between a married couple. Husband and wife may appoint each other immediately. However, it's very common in a power of attorney document to have backup individuals that will serve for you if the primary person can't do it. And in those cases, a lot of the time we use what's called this springing power. And what that means is that the power in the individual is not created just by your signing that document. That power is not instilled upon the individual immediately. It only comes into play if you were to become incapacitated or lose your mental faculties. And at that time, if you were to become incapacitated in that way, the authority you've created springs into action, and that's why it's called a springing power. So oftentimes we'll use a combination where husband or wife appoint each other immediately, but the authority granted to the backup people, which might be their adult children or someone else, is a springing power, and that power doesn't come to life until later. So that's the power of attorney.